Good morning. I'm Gary DeWaal, and this is Bridging the Week for May 16th to 20th, and today is May 23rd, 2016. Two related broker-dealers agreed to pay the Financial Industry Regulatory Authority $17 million to resolve charges that they did not implement and maintain an adequate anti-money laundering program. More significantly, the AML compliance officer of one of the broker-dealers also paid a fine and agreed to a temporary industry suspension for her alleged role in her firm's violations. In addition, a famous professional golfer settled charges by the Securities and Exchange Commission for his role in a larger alleged insider trading scandal, but was not charged with insider trading himself. We have only a few matters to cover this week, so let's get started. Raymond James & Associates, Raymond James Financial Services, and Linda Busby, the anti-money laundering compliance officer for Raymond James Associates, agreed to settle charges by the Financial Industry Regulatory Authority that, from at least November 2011 through June 2014, both firms failed to implement and maintain an adequate AML program, and that through February 2013, Ms. Busby was responsible, at least in part, for Raymond James Associates' violations. During the relevant time, Raymond James Associates and Raymond James Financial Services were Securities and Exchange Commission registered broker-dealers and members of FINRA. Raymond James Associates was a full-service broker-dealer, providing clearance, execution, and custodial services, and also engaged in correspondent clearing services for other firms, including Raymond James Financial Services. Raymond James Associates agreed to pay a fine of $8 million to resolve FINRA's charges, while Raymond James Financial Services agreed to pay a fine of $9 million. Each firm also agreed to retain a consultant to review its AML program. Ms. Busby agreed to pay a fine of $25,000 to resolve FINRA's allegations and not to associate with any FINRA member in any capacity for 3 months. According to FINRA, during the relevant times, the two firms experienced material growth, but, quote, did not dedicate resources to match the firm's growth with reasonable AML compliance systems and procedures, end of quote. This permitted, said FINRA, quote, certain red flags of potentially suspicious activity to go undetected or be inadequately investigated, end of quote. Among other things, said FINRA, Raymond James Associates did not have a single written procedures manual describing its AML procedures, while Raymond James Financial Services failed to establish and maintain a quote-unquote adequate customer identification program as part of its AML program. FINRA also alleged that both companies failed to develop and implement surveillance reports to help detect certain suspicious activities. Previously, in March 2012, Raymond James Financial Services agreed to pay a fine of $400,000 to FINRA to resolve charges that it failed to implement policy and procedures reasonably designed to identify and cause suspicious activity reporting of transactions in the account of a customer that allegedly was operating a Ponzi scheme. The Securities and Exchange Commission settled charges against Phil Mickelson, a professional golfer, for trading and making profits on non-public information regarding a publicly traded company he received from an individual to whom he owed money at the time. The individual, William Walters, is a professional sports gambler, said the SEC. According to the agency, on multiple occasions from 2008 through 2012, Mr. Walters received, quote-unquote, highly confidential, non-public information regarding Dean Foods, a publicly trading company, from Thomas Davis, a director of the company. The SEC claimed that during the relevant time, Mr. Davis had significant financial problems. The SEC charged that Mr. Walters helped Mr. Davis with his financial problems, providing him with almost $1 million in return for the insider trading tips. Mr. Walters passed along to Mr. Mickelson some of the trading tips on Dean Foods, claimed the SEC. While the SEC charged Mr. Walters and Mr. Davis with illegal insider trading under applicable law and SEC rule, Mr. Mickelson was solely charged with being, quote-unquote, unjustly enriched for trading on the insider tips he received from Mr. Walters. The SEC provided no law or statutory rule as the basis for its charges. To resolve its charges by the SEC, Mr. Mickelson, without admitting or denying any of the SEC's allegations, agreed to disgorge almost $932,000 US, his trading profits from the insider tips and interest. The SEC seeks disgorgement of profits, a fine, and other relief against Mr. Walters and Mr. Davis. Separately, the U.S. Attorney's Office in New York City filed criminal charges emanating from the same alleged facts against Mr. Walters and Mr. Davis, but not Mr. Mickelson. Mr. Davis pled guilty and admitted to his participation in the alleged illegal scheme. An unnamed whistleblower will receive an award of between $5 and $6 million US because of information voluntarily provided to the Securities Exchange Commission that led to a successful enforcement action. According to the SEC, the claimant was a, quote, former company insider whose detailed tip led the agency to uncover securities violations that would have been nearly impossible for it to detect but for the whistleblower's information, end of quote. This is the SEC's third largest award to a whistleblower. Previously, the SEC has granted awards as high as $30 million and $14 million US. Whistleblower awards may be from 10 to 30% of collected monetary sanctions in excess of $1 million US, resulting from an SEC enforcement action. Recently, the Commodity Futures Trading Commission announced a $10 million US award to a whistleblower under its equivalent process. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. By the way, don't come looking for Bridging the Week next week, as it will be the Memorial Day holiday in the U.S., and I will be taking a break. I'm Gary DeWaal, and until 2 weeks from now, ciao.